Yeah, hi, good afternoon. We can hear you. And I think, of course, only I
Almost.
am visible to you because
Okay.
the laptop is kept the other way.
Okay.
Yeah. But I think everybody else can see you in the hall. We have about 100 people in the hall, and
Great.
they can all see you.
Excellent. Excellent.
So you will be sharing your slide, right?
Uh,
Or
I'm not
should
able to, if you don't mind, because I'm not able to dial in from my laptop for some reason. Uh, will you
okay.
be able to share the slide and I can walk
Yes,
through it?
yes, yes, yes. Yeah, I can
Let,
do that. I can.
let me see if I'll give it one more try to see if I can do it. Otherwise,
बता दो कर दिए. Well, I'll do it. No problem.
okay.
Tell him before your slide is in front of us. Your slide is in front of everybody. I'll just share it with you also. Just a second.
Great. Great. Excellent. Thank you. And how much time do I have? Around 30 minutes, 45 minutes?
30.
30? Okay, great.
30 minutes.
Yes. So, good evening, everyone. It's good morning for me. As you can tell, I'm in California, but I appreciate everyone staying back in the evening for this presentation. And typically, I present to a room full of people in front of me so that we have time for Q&A as well, an opportunity for an interactive session. But given where I am and given where most of you are, as I understand in India, this will have to be an online session where I guess I'll be reading from these slides. But I also have my contact information at the end. So if anyone has any follow-up questions or comments, feel free to reach out directly to me and we can have a sort of a conversation offline as well after the session over the next few days. So my name is Anil Advani. I'm the managing partner of Inventus Law. We are the global technology law firm. We're based in Silicon Valley, but we have offices in India as well. What we do is we represent and advise early stage startup companies, founders, angel investors, VC investors across the spectrum, from advising on how to set up through the funding, acquisitions, intellectual property, commercial agreements, global structuring, all of that. The topic for today that I'm presenting on, I was asked to present on, is really structuring India-US operations. And that's, as most people in the audience would know, I'm assuming are practicing CAs, would know that that's a very hot topic. I'm sure all of you, most of you, if not all of you, are getting questions from your clients on how to do these structures. In a typical structure or scenario, you have founders sitting in India that have developed some technology, mostly SaaS enterprise, and then they realize that that technology can be used across, not just in India. And many times they've started out with a few reference customers in India, but then they realize that the customer base can actually grow higher, and they decide that, and for good reason, they decide that they should consider a different holding structure than the typical India private limited company. And that's where we typically come in. And I would hope that you guys in the audience would bring us in when your clients call you for advice and help on structuring these. So we have expertise on the US corporate side and the Indian corporate side. And I will talk about the various options of structuring, but mostly, as you can imagine, into a US parent company, parent holding company with an Indian subsidiary. That's where sort of most of the action is. The others are set up as options that you should be aware of, and I'm sure most of you are aware of anyways. So I'll hit the very highlights of that, but dwell more into the US parent company. Minoji, next slide, please. Yeah. I'm sorry, not yeah. If we can move to the next slide. Can I do this on my own here? Or no. Uh, can we move to the next slide?
We are on the next slide. We are on the next slide.
Somehow I can't see it. Yeah. Okay. Oh, okay. So this is good. Yes. So this is the main structure, right? And if folks in the audience, they walk away with just one thing from this presentation, it should be this one. This is where we set up the US holding company with the Indian subsidiary. And many times I'm asked the question of what entity it should be. And I would say for mostly almost all 100% of the times, if you're a SaaS company, enterprise company, if you're a startup technology company that's looking to raise money from investors, grow into a typical Silicon Valley company, a company that smells, walks, talks like a Silicon Valley company, which is a high growth technology company, then this is the model that you should end up with a Delaware holding company and a C corporation. And the reason we need a C corporation is because it's a tax blocker. It's similar to a private limited company. You can also set up an LLC, but the LLC is a flow-through entity, which means that the entity itself is discarded, similar to an LLP in India or an LLC in India. The LLC is discarded for tax purposes, and the IRS will look to tax the shareholder of the LLC or the LLP. So if you are sitting in India as founders, you would be subject to tax in the US. So we obviously don't want that. Or the Indian company, if that's a shareholder of the LLC, then it becomes subject to tax in the US, which again, we don't want. So, and Delaware C Corp, the other advantages are many times founders end up moving to the US to build the business, right? After their first round of funding, when they've realized the customer base is largely in the US or global, many times founders move to the US. And if they move to the US, their stock also qualifies for QSBS, Qualified Small Business Stock, which means that when they sell their shares, 100% of the shares are exempt from federal taxes. If they hold it for 5 years and other limitations apply, which in most cases they would apply. So that's a significant tax benefit if you're a founder holding shares. And if you decide to move to the US, you don't have to pay federal taxes for your capital gains when you end up selling the shares. And similarly, your venture capital investors, private equity investors that are investing, they would require you to be a Delaware C Corp, because when they invest and the shares they get also qualify for QSBS, Qualified Small Business Stock. And that exemption is only available for C corporations, not for LLCs and not for S corporations, and not for services companies. So they're only available for sort of product companies, the typical Silicon Valley high growth technology companies. So if you're one of those, you should always consider this would be the only right answer for you, despite what others might say that there might be other tax benefited sort of beneficial entity structures. But please just stick with the Delaware C Corporation. The Delaware C Corporation in turn will set up an India private limited company and a subsidiary. Again, we want a private limited, not an LLC, not an LLP, because again, similarly, we don't want the Indian authorities to discard the LLC or the LLP in India and subject the US company to for taxation in India. So we want a separate tax blocking private limited company in India, which is operating the business in India, hiring the folks in India, including the founders that are sitting in India. All of the operations in India are undertaken by the private limited, so that the private limited pays taxes in India, and there's no tax implication of flow through or discarded for tax purposes that goes into the USC corporation, the holding company. Once we've set up the structure, we would also issue founder stock to the founders. Obviously, if you're sitting outside India, then FEMA does not apply. And I know this has been a whole day of FEMA session, so I'll not go too deep into the FEMA regulations. But one of the key elements is that if you're an Indian resident, which means for FEMA purposes, you're subject to Indian taxes in that particular year, then you have to comply with FEMA regulations. And we had new regulations come in August of last year. So you have to be careful about how you structure the purchase of your founder stock. So what you can't do, which you can do in most jurisdictions outside India, you can't just buy your shares in the US company that you would otherwise buy. So if two founders come into my office in San Francisco, it's very easy because they can buy shares, pay $100 into the US company account, buy the shares directly from the US company as Indian resident. And it's not US law, right? So if you end up working with US lawyers who don't understand FEMA, they will have you buy shares directly because there's nothing wrong. They're not doing anything wrong. Delaware law allows you to do that. US tax law allows you to do that. But you will end up with a FEMA violation, which obviously, as all of you on the audience know, is a potentially criminal violation as well. So please work with experts who understand FEMA if you're an Indian resident or if you're advising Indian residents, and not just any online service or US law firm that doesn't understand that Indian residents are subject to different regulations. So that's the structure. The US Delaware C Corp will also have a global option plan. When you hire people in India, those employees in India can also get options in the US option plan. And then that's the entity set up for like controlling everything, including the operating the global business, your seed investors, angel investors. And again, if you have angel investors from India that are investing from India, they will now have to go through ODI. They cannot invest in a safe instrument directly into the US. it will have to be equity instruments, and they will have to go through ODI, which again, I'm sure people in previous panels have discussed how to do that. But the key element of all of that is if you are a company founder or advising the founder of an Indian company that's setting up a US holding company, then please understand that you get the Indian company that you're setting up needs to get a UIN number, and all of the investments, your founder stock, your partnerships, LLPs, whatever you set up to buy your founder stock, all the angel investors, all of that has to go through the same UIN number. Many times angels have their own banks and the company has a different bank, and they try to wire from their own bank into the US company. That is not permitted anymore. It has to flow through as an ODI, and all of that has to flow through the one UIN number set up with that one bank that the company set up. So, as a founder or someone advising the founders, please be very careful to make that explicit to the angel investors coming in that they should not be trying to wire the money directly from their own personal accounts. It has to go to the company's account set up with the UIN with the Indian bank there. Hopefully that's clear. But if we have any questions, we can discuss offline. Similarly, your investors will come in. The VC investors, as you grow the business, the investors will come in into the same company. So we are setting it up, as I mentioned earlier, as a company that smells, walks, talks like any other Silicon Valley company. So from a legal structuring perspective, from a holding perspective, anybody that does diligence, your customers in the future, because large enterprise customers will do diligence, and they will want to see, how the entity is set up, where the intellectual property is set up. So the goal of this is to set it up as a company that everyone's comfortable with. The option pool resembles an option pool of Facebook, Google, Apple, all the successful companies that you aspire to be. The intellectual property is held in the US. So once the India subsidiary is set up, the founders, as I mentioned, will be hired by the India entity. All the employees in India will be hired by the India entity. All the work they do on the ground will be assigned to the India entity as part of their employment with the India entity. The India entity will enter into a services agreement, master services agreement, where all the work done in India is assigned to the US and owned by the US. In return, the US will agree to pay service fees, which is based on transfer pricing. And again, I don't need to tell the audience what transfer pricing is, but again, if you're advising your Indian founder clients, I would assume that you are the ones advising them and putting that on paper. But it's important again that every dollar that's flowing in from the US to the India entity is structured subject to transfer pricing regulations because they are both affiliated entities, and Indian transfer pricing laws will apply to those payments. We can go to the next slide. Right. So we've talked about the details of the option. It will be a C corp. Founder stock is held there. The IP, very importantly, once the IP is owned by the US company as part of the master services agreement, then the US company will file for IP protection so that it owns the IP. And that's where, as I was saying, as you start working with large global enterprises, mostly based in the US or Europe, they will also want to make sure that the intellectual property is registered in the US so that and it's owned by the Delaware company so that when they negotiate license agreements, customer agreements, SaaS agreements, the reps and warranties, the protections of intellectual property, if something goes wrong, their ability to foreclose on the intellectual property or access intellectual property, all of that is structured in a Delaware company that they're very familiar with. Work for global enterprise companies to work with Indian companies or even Singapore companies with IP sitting in these foreign lands, according to them, is complicated. And your job as founders is to make sure you set up a structure that's ideal structure for growth, especially if your market is global technology companies, right? So this is the model that's structured for growth. Everyone understands it. The general counsel, law firms, advisors, tax advisors, CPAs, everyone understands how Delaware structures are set up, what the tax implications will be when you're issuing options, what are the tax implications for employees, for the company, what are the withholding requirements. All of that has been set up over hundreds and thousands of transactions in the last 40, 50 years. So your job is to keep it as simple as possible so that the company can get to the next level of growth. We can go to the next slide, please. As I mentioned, it's so in the next slide where we have option. Yeah. No, the next slide, please. Right.
I'm on hybrid investment model.
No, this is it. The advantages, yes. Or maybe it's coming slower on my side. Yeah. Okay. This is the right slide. The advantages of setting up a US parent company. Uh, it's very easy to set up. I mean, a lot of times I get questions from apprehensive founders who are concerned about the cost of setting up the US company. Is actually, I would argue, setting up and also maintaining a US holding company is cheaper than maintaining the Indian private limited company, because you're not dealing with GST in terms of the sales revenues coming in into the US. A lot of the tax implications, regulatory implications, compliance, licensing, the FEMA or the money coming in and out of customers, especially as I said, if you have customers outside India, global customers that are making payments in and out of your account, or even vendors. Doing it from a US company, there's no restrictions, control restrictions, no reporting requirements for money coming in. Obviously, other than annual taxes that you have to pay. But other than that, this, unlike India or a lot of other jurisdictions, it's very easy to maintain. And I joke about this, but it's true. I've not had to look at the Delaware code for the last 10 years because it hasn't changed, right? So as a business, you get very sort of certainty about what you're doing and how this will hold up in the future. Whereas India, there's every year with monsoon session of parliament or this session of parliament, there's something or the other that new comes in for corporate law, tax regulations, GST regulations. So you're always trying to figure out, and you're getting tax notices that you have to comply with, which I guess for this audience is great because that's great business for you guys because you're advising these companies on these matters. But from a founder's perspective, if you're looking to set up an easy sort of a structure that's easy to set up and also maintain the future, Delaware companies, again, widely recognized across the world as the easiest, and everyone that's comfortable with it. The laws don't change, the tax regime doesn't change, the structures, the processes are set up already. So as a founder, you can spend a lot of your time dealing with actual business issues, technology issues, sales, customers, then with tax advisors, legal advisors, other sort of compliance related matters. Um, there's and your investors, your global investors will require, in many cases, if you're working with an accelerator or a VC investor, in most cases, especially if you're a global business with global customers, your investors will require you to be a Delaware company. So if you set up an India company, and we'll talk about that, and you have customers in India, you got to a certain level of growth, and then you decide that you want to raise money from, let's say, global investors. At that time, it becomes very difficult to flip that holding company into a US holding company. But you have to do that because that's where your investors are requiring. So the other thing to keep in mind is this decision to be a US holding company should be made very early on. You should not wait for, having done a lot of these things on the ground in India, including raising money, have customer revenues, file patents in India. Don't wait too long for it, because flipping that over to a US holding company becomes complicated. You have to deal with FEMA, you have to deal with tax consequences. The valuation of the India company shares has gone up. So for the US company to buy those shares, the US company has to pay a lot more. Whatever that value is, the shareholders in India have to pay taxes on that. So lots of issues in flipping an existing holding company. And we've done that. We can certainly help. And I'm sure people in the audience have advised other companies in flipping those. But the advice should always be do it early enough so that you don't have to deal with a lot of these issues in the future. Because the more you wait, the more activity and value you've created in India, the more complicated it will become to flip that structure over. Also, when you're looking at an exit option, right? When you've set up a US Delaware holding company with IP in the US company, your stock options, all of that structure in the US company. Whenever you get to an exit, if it's a large buyer, Google buying you, they will be able to do diligence like any other Delaware company, right? So it's easy for you. There's no roadblocks. They don't have to worry about tax consequences. The intellectual property is held by the Delaware company, registered in the USPTO. Diligence across intellectual property becomes very easy. Getting reps and warranties, negotiating these purchase documents, investment documents, even if you have to list on an IPO in the US, which is likely to be the more likely exit, either selling to a US company or listing in the US for a high growth technology company. If those are your exit options, which I would argue they would be more likely to be, then again, you're better off setting up a US holding company that you can flip into an exit at the US company level. We can go to the next slide, please. Yeah, the disadvantages. Are we there? Yeah. So the disadvantages of a US holding company, and again, these are disadvantages of any non-India company. So if you end up setting up a Singapore company or a Cayman company, you have to deal with the same disadvantages. When you're setting up the initial structure, you do have to, as I mentioned, go through FEMA compliance, and that's not as easy. So you need to work with good counsel and good tax advisors and CA firms in India. So you want to be careful about that. You don't want to run into round tripping issues or FEMA compliance issues, because that can be very costly and sometimes lead to criminal prosecution. So you want to be very careful about how you're structuring. So that's somewhat of a disadvantage if you're not doing this properly. India has POEM regulations, although they only come into play after you get to gross revenues of 50 crores or more. So initially you're fine, but then again, if you're a founder of a SaaS company, enterprise company, a technology company that with customers outside India, and once you're getting to that 50 crore revenue target, very likely you should be looking to move outside India, preferably where your customer is. If the customer's in the US, then looking to move to US. If they're in Asia Pacific, then maybe looking to move to Singapore. And once you do that, then POEM should obviously become less relevant. If you move as the management already and the CEO and the management move outside India, then the control gets outside India, and then POEM in India becomes less of an issue. But it is something to keep in mind when you're structuring and making decisions on the ground from India. Um, so some of the AIFs are not able to invest in non-India companies, and it's become even more and more difficult under the new sort of structures. And they can invest with SEBI approval, but SEBI approvals sometimes take 3 months, 6 months. So if you are looking to negotiate or have a term sheet from an India AIF, then that's a disadvantage because they may not be able to invest in your US company. What we've done is we've created a put option structure, a parallel structure, and it only works if you haven't you're raising a significant amount of money, you have investors, let's say investing in the US, and then in AIF also as a follow-on investing in India. In that model, what we do is basically have the AIF investor invest in the India entity, get a CCPS in India, for example, and that get parallel rights to the same rights that they would get in the US company. They can negotiate as contract on a contractual basis into the US company. So they're still complying with FEMA because they're not investing. The money is not leaving India. It's actually coming into the Indian entity. They're getting their shares in the India entity, but they're getting similar rights, veto rights, board rights, inspection information rights in the US by contract, because the US is a parent of the India. So they're getting the benefit of that investment. They also get a put option right where upon the exit of the US company, they can sell their India company shares. So they're made whole in the sense that if whenever there's an exit of the US company, they get the exit proceeds like as if they had invested directly in the US company. And we can do a separate session because that's a whole lot of issues and structures and tax and other terms that come into play. But I want to hit that part also. For AIS, if you set up a US company and an India subsidiary and are looking to raise money from an AIF investor in India, we have a structure that allows for it with some limitations on how and how much money you're raising, because it's somewhat more complicated and therefore more expensive. And also, it shouldn't be done in vacuum, right? It should be done as a proper round in the US with the AIF coming into India. Uh, yeah, we can go on to the next slide. I guess I have a few more minutes, so I'll go quickly through the rest of the slides or the other options. Uh, yeah, the hybrid investment model is where you continue to have the Indian parent company, and everything remains the same. And then you create a US company, right? So the US investors, you invest in the US company, and the Indian investors continue to be in the US. Again, not a great ideal structure, but it's something that if you are not, if you have AIFs already, and because of tax issues, you're not able to flip into a US holding company, then it's a plan B or option two, only where option one doesn't sort of work. As I mentioned, it's not a great option for raising investments from US or other investors, because if the holding company is in India, then investors have to invest in India. They're concerned about exit opportunities, angel tax, lots of issues, and they will push you to be a US company. But if you're not able to be a US company for tax reasons, you've got to a point where it's too expensive, too complicated to structure, then you can look to create a separate hybrid model where they invest in the US company and you continue to run the India company. We can go to the next one, next slide. This option 3 is something that we work on, I would say 10% of the times, where it remains an India company. Everything remains in the India parent level, but you create a US holding company, or not a US subsidiary really, to market your services. So many times services businesses, right? They're not looking to raise money, venture money from outside investors. They call us because the only thing they need from the US is to create an entity that can be front end for the services business, right? For service customers. So if you are providing development services, marketing services, accounting services, all sorts of professional services, and you're not looking to raise money for your business from outside investors, then you can continue to run your India company as your main parent company. The India company can set up a subsidiary. The subsidiary will have some sort of a license if needed, and basically transact business with US customers like any other US company, right? But the money will come into the US company, your subsidiary, and then there'll be either a license fee if you're licensing technology, or a professional services fees for the services performed by India. So it'll be the US company is a subsidiary, and it's a front end for just taking and signing customers, and a flow through for those customers to be executed. The service should be executed on the ground by India. And there'll be again a transfer pricing where some portion of the revenues in US will be subject to transfer pricing tax in US. 95% of those revenues will be paid into the India company as part of the service fees, because the India company will still continue. If you have hundreds of people employed in India, they'll continue to be employed in India. They'll continue to do the same service, except they're doing it as on behalf of the US company, as a US company is the customer, and the US company will then outsource that service to the end user. But all of those payments will be flown through again to the Indian company. So nothing changed on the ground in India. I think my time is up, so I'll just flip through the last slide. And just as an example, many times we also get questions about Singapore holding company. We can talk about that. I mean, this is a good option if you're looking for, if your business is a consumer focused business, if you're creating a Make My Trip or something, and the focus is 100% consumers in India, or perhaps Asia Pacific, and you, for good reason, your investors require to be outside India, then you can look to consider like a Singapore holding company or even a Cayman holding company. But I would argue that it's a terrible option if you have enterprise customers and you're looking to become a global company. Singapore holding company is a great model for consumer businesses where the focus is India consumer, or even Philippines or other parts in Asia Pacific. But it's a terrible model for all other options, because if you're a Singapore company trying to sell to enterprise clients in the US, that's not going to work. Your intellectual property is in Singapore. That creates complications. If you are looking to raise money from US investors, they don't like investing in non-Delaware corporations. So that will be a roadblock for you to raise money. Sometimes they will, but you're creating roadblocks for them to sort of jump over. So that just becomes more complicated for them. So I think that's the overall. And we can talk about, as I said, offline about any specific follow-on questions anybody has. The last option is Cayman Corporation. That's the least preferred option. It's subject to a lot of regulatory review, diligence. It's been abused in the past, and there's no reason to do it unless your investors, for whatever reasons, let's say you're raising money from Middle East investors, and they don't want to be subject to Delaware or US compliances or disclosures because they will be shareholders, then perhaps consider a Cayman parent company. But otherwise, it's the least preferred option for structuring a US-India sort of business structure. That's the end of my presentation.
Thank you so much. And I think it was a marathon presentation to conclude the day one of the FEMA workshop. And thank you so much, Anil sir, for joining us all the way from US and taking time out and talking to all of us. And we look forward to interacting more in future.
Yes. No,
Thank
thanks.
you so much.
Have a good night, everyone.
Thank you so much.
Bye.